Good afternoon. We'd like to welcome you to today's program, Banning Rosa Parks, the Impact of Book Banning on Civil Liberties, sponsored by the Women in Law section, the Committee on Diversity, Equity, and Inclusion, the Committee on Civil Rights, the Task Force on Racism, Social Equity, and the Law, and the Committee on Continuing Legal Education of the New York State Bar Association. Today's program will run from 4 to 5 p.m. And during the course of the program, if you would like to pose a question to today's speakers, please feel free to use the Q&A tab in the Zoom portal. And it is at this time, it's my pleasure to turn it over to the new chair of the Women in Law section, Kimberly Wolfe-Price, to get us started with some welcoming remarks. Kim?
Thank you, Ernesto, and thanks for everything you do to keep this section running. Thanks everyone for joining us today. As Ernesto said, my name is Kim Wolfe-Price, and I'm privileged to be the new chair of the Women in Law section of the New York State Bar Association. In my day job, I work for the law firm Bond, Shennick & King. So thank you for joining NYSBA today for today's really important program. Sincere thanks to Chair-elect Fretra da Silva, who you will meet shortly, for all the work she did in putting this together, this program, bringing it to life. And thank you, of course, to our speakers. It was wonderful to get to know them for a little bit before this started, and I'm really excited to hear what they have to say today. Bar associations provide incredible resources to us as practitioners and professionals. The New York State Bar Association is an incredible organization. Becoming involved in bar association sections, like the Women in Law section of the New York State Bar Association, allows members to plan programs, serve on awards committees, track legislation, edit magazines, and much more. I encourage you to take the time to look further into joining this section, the Women in Law section. Please reach out to me or any of our executive committee members if you have any questions. We would appreciate the opportunity to tell you more and discover where your skill set would shine in the Women in Law section. Chairing a bar association section is a lot of work, but the work I have been putting in pales in comparison to what I have gained from getting to know the incredible members of this section. From our past chairs, including our immediate past chair, Cheryl Geller, to the chair-elect, Fretra da Silva, and to the many amazing women who will give remarks next, the many wonderful women and men who work on our executive committee and are part of the Women in Law section, as well as the great team at NYSBA, like Ernesto, really makes this a wonderful experience. So I encourage you to get involved. So now I will turn this presentation today over to Fretra da Silva, who during her day job is head of legal transaction banking at America's Standard Chartered Bank. Thank you so much, Fretra. Thanks everyone for joining us.
Thanks so much, Kim. And again, welcome. We're so excited about today's program. And I'll just get us started because we want to have as much time to cover this topic as possible. We are so fortunate to have two wonderful speakers today to kind of parse out some of the issues and some of the challenges that come with book banning in our country today. First, Professor Gloria Brown Marshall, who is Professor of Constitutional Law at John Jay College of Criminal Justice. She teaches classes in constitutional law, race and the law, evidence, and gender and justice. She's taught at the Americana Studies program at Vassar College prior to joining John Jay, and she has been a civil rights attorney who has litigated cases for the Southern Poverty Law Center in Alabama, Community Legal Services in Philadelphia, and the NAACP Legal Defense Fund. A prolific author and playwright, currently she's working on her first novel. Professor Brown Marshall is widely recognized for her work with civil rights, social justice, and women's equality issues. Welcome, Professor Brown Marshall. Also, Nikia Martin. Nikia is Assistant General Counsel at the New York Public Library, Astor, Lennox, and Tilden Foundation, a nonprofit organization that serves as the nation's largest public library system. Nikia is a general practitioner there, serving the day-to-day wide range and variety of areas that are covered by the library. She has served as a law clerk for the Superior Court of New Jersey Appellate Division. She's a graduate of Howard University Law School and undergraduate degree at John Jay College of Criminal Justice. Welcome to you both. And let's get started. Professor Brown Marshall, I would ask you to start us off, just kind of setting the historical context for our discussion today.
Thank you so much, Fretra. And thank you, Nikia. It's my honor to have a graduate of John Jay on this panel who has risen to such high levels and continue to make us all proud. I am honored that the New York State Bar Association sought out not just the two of us, but for this Juneteenth time period for us to discuss this issue. I think it is a cross-section of race and the law, as well as civil liberties and civil rights that we're discussing today, with the general sense of what is a book and why would someone want to ban it? How long has this been going on? Well, actually, book banning has been going on for centuries. As a matter of fact, when we look at some of the time spent banning books, we can go back to the 1400s. So generally, and I've just come from Florence not too long ago, there is a major case in 1498. Savonarola in Florence wrote the phrase bonfires of the vanities. We think this is a modern phrase, but it's not. The bonfires were the flames in which the books were tossed. The vanities were the books. It was thought that some of the things that were being written by people did not deserve to be read. As a matter of fact, the three areas I would say that focus the ideas behind or motivations behind book banning would be controlling societal progress and ideas, hiding information that will lead to social change, and the power to do it. And so when we look over historical references of law and social change, we see that there's always been a pushback to social change, but does one have the power to actually ban information, to ban a book? So when we get to the 1500s, who had the power? The Catholic Church. And so the Catholic Church would ban the Bible. So for many centuries, the Bible was only written in Latin. The access to the information in the Bible was given to us through priests, and only through priests. They were the only ones to allow the general public to know what was in the book. The reason why some of us refer to the King James Version of the Bible is because King James was the person who decided to go against the church and have a book called the Bible that was interpreted in regular English for the regular person to actually read and decide for themselves. Once again, the distribution of information, the power to stop ideas, and the sense that progress was something that the status quo did not see in their favor. When we go further, and some of these examples, like Galileo, and I think about, what does Galileo, Toni Morrison, Shakespeare, Amanda Gorman, Anne Frank, and CIA operatives have in common? In modern time, their books have been banned. And when we think about book banning in the modern time period, I want us to think about, once again, the control of societal change. Once we begin to see women advance, immigrants come in and decide to be a part of this society and yet bring with them their own ideas from the old country. Unions start to be created. This sense that people who are of color or different ethnicities want to have their say in society. And sometimes they want to write or stand up in protest. That sense of protest is seen as a challenge to the status quo that has the power to say, not only are you not allowed to write what you're writing, but you're not allowed to disseminate it. We will take it, confiscate it, and burn it. And so when we see, even in other countries, we think about these great books that we read today that they become classics. Many of them are banned or on the banned list. So it's not new when Galileo had to say, either the world is not round and the earth is the center of the universe and everything is formed around it, if you want to, at 70 years old, not to face prison or possible torture. That's the power to say, Galileo, say you're wrong. And if you don't say you're wrong, then you will probably die at 70 years old in prison. Galileo denied the fact that the earth circled the sun in order to live. And many of us to this day are afraid to stand up to the power of those who want to undermine the dissemination of information, societal change, and new ideas. When we get to lawsuits, we begin to see that Charles Darwin had his book challenged, and the Scopes trial, that was the trial that many people remember that challenged whether or not people were from evolution or were they created in the 7 days in the Bible. That was an actual legal trial with with Charles Darwin's book being at the lead of the issue, but it was also the attorneys, and the attorneys were ones who were then pitted against each other, societal change or evolution, new ideas. The idea behind it was, should these books, Darwin's, be in the schools? Should they be allowed to be taught, and should they be in the libraries? Something that is very much part of what we're talking about today. The Evans versus Selma case, and the Evans versus Selma case is a 1924 case. That was a case whether or not Bibles should be allowed in libraries. When you start thinking about this issue of religion and power and control, even today, underneath what we're debating is the idea that somebody has a moral compass that is better than someone else's, and their moral compass should dictate what books should be allowed and what people should be allowed to understand. Many of the cases that involve book banning involve schools, in the sense that K through 12 education is one in which all people should, under our laws, be educated, but what type of education should they consume? What should our children learn? And when should they learn it? When is the education appropriate? Now let's take a moment to look at Juneteenth. Juneteenth is a new federal holiday in which June 19th is commemorated as the Day of Independence. June 19th, 1865 is when the order of General Granger, the Emancipation Proclamation that freed Africans who were enslaved in the states that had seceded from the Union. However, the Emancipation Proclamation that Lincoln signed was signed July 22nd, 1862. It became effective on January 1st, 1863. However, the information was not received by those enslaved until 1865. That delay, that hiding of the information, once again, that order of General Granger that was presented in Texas gave absolute equality to all enslaved people. Those words, absolute equality. The first time I read that was the order, I was stunned into silence. Stunned that an order in 1865 said those who had been enslaved were now free with, quote, absolute equality. Now we see why it was hidden. And then for some reason, the order itself disappeared from the National Archive and was only found a few years ago. Once again, a hiding or banning of information by someone who was working in the National Archive to prevent those who wish to learn more, to have more ideas. They had the power to do it. I want us to think about the fact that the lynchings in America, there have been over 5,000 recorded, and the types of abuses that have taken place in this country based on race were not allowed to be discussed in schools. There was a assault. There could be the burning of a person's farm, a killing of their farm animals. They would have to leave town if they actually even said this, let alone wrote it. But this was also during a time period in which it was said that people of African descent and other people of color had no history, that their history began with the European. Now we have, and I want people to know this name, Dr. Carter G. Woodson. Dr. Carter G. Woodson is considered the father of Black history. He is the second graduate of Harvard with the doctorate in history. And this man was the one who said, yes, we do have a history, but people are refusing to write it, to publish it, and to allow it in schools. So once again, the power to prevent it from being disseminated, the power to allow people to believe that there are certain people who are without contribution to the greater society. I want us to understand that Dr. Woodson was also the father of Black History Month. And so he started Black History Month in February because it contained the birthdays of both Frederick Douglass and President Lincoln. That's why Black History Month is February. I want us to also understand that he began the African American Journal. This African American Journal was a journal that contained African American history, because another part of book banning is the inability to actually get this information published. And there's been a great deal that's taken place in the publishing world in which we've said, and many people, and I'm at a writers' conference right now, that what the history is of certain people, what their perspective is on the world is not being known, is not being published, and is not therefore being read, so that we have such limited viewpoints of other people. Reading and the ability to understand the other gives a more broad-based sense of our communities, our society. And so book banning is old. Book banning has a system to it that maintains the status quo of certain people in power. There's a sense that we don't want progress, and we don't want a deeper understanding of the other person. Dr. Carter G. Woodson said that if you control a person's mind, you control their body. You don't need to do anything else once you control the mind. And the one thing that a book does is expand the mind. So limiting or banning books is not just a poor attempt to keep a society restricted to those who are already in power. It limits those people banning the book, as well as those people who do not have access to it. I want to end with this, and I think it's important for us to understand that Juneteenth is a commemoration of freedom. But remember that freedom was delayed because the information was hidden.
Thank you so much, Professor Brown Marshall. And I just want to remind everyone online that we have a chat function and a Q&A function. And if you have questions, we're going to allot for quite a bit of time at the end so that we can have some back and forth with the speakers and those attending the seminar today. So please insert your questions and we'll get to them later on in the discussion. Now that we have some foundation, let's think about what's happening in these last couple of years. PEN America reports that since January 2021, 306 educational gag order bills have been introduced in 45 different states. And they have 22 of them have become law in 16 states. It's just, it just seems incredible in a negative way. And beginning in the school year of 2021 to 2022, book bans became increasingly more common features in public schools, exceeding 4,000 individual bans from July 21 to December 22. Now, with that trend, Nakia, would you help us understand the current legislative landscape that's at the foundation of these restrictions?
Sure. I just want to start by saying thank you, Fretra, for putting this panel together and offering me the opportunity to sit in and speak on this very important topic, particularly with Gloria, who is an expert in the area of constitutional law and civil rights and race and law. It's truly an honor and a pleasure. Thank you. So Gloria, thank you so much for setting out the context and the historical context of book banning, which goes back many, many years, and I learned a lot from your initial comments. So yes, book banning has a long history, but as we all have noticed in recent years, it has increased. So to what is due this recent increase in requests to ban books and to limit access to books? Well, it dates back to the George Floyd murder of 2020 and the civil justice movement that followed. After the civil justice movement and the George Floyd murder, the Trump administration at the time unveiled the 1776 Commission, which set out to prohibit the use of critical race theory in federal offices. Instead, the Trump administration wanted to focus on patriotic education. They wanted to eliminate anything that had anything to do with racial education, racial justice education, and critical race theory from the government, from the workplace, as well as from the classroom setting. Obviously, the Biden administration rolled back those policies, but it had a lasting impression. And so since then, there's been a precipitous increase in requests to ban books on topics related to race, racial justice, and civil rights and progressivism. That has led to a flurry of activity in various state legislatures across the country to ban books and to limit any sort of discussion in schools in particular about race and critical race theory. Since January of 2021, state legislatures have introduced over 120 bills that sought to ban critical race theory from K through 12 schools. In terms of the book ban legislations in particular, they're under one bill that was introduced in Iowa attempted to limit any sort of dissemination of materials in K through 12 schools that were viewed as being obscene or harmful for minors. That bill had a penalty for violations that included jail time of up to 2 years. Last year, a Republican state legislature in Texas called for school districts to review whether whether they held any of the 850 books that he listed as making kids uncomfortable. And he proposed that hundreds of titles be removed from schools. Book bans have surged in Florida, which has gotten a lot of public attention, as a series of laws have been enacted to limit curriculum that discusses race and critical race theory. 565 books have been banned in Florida during the period of 2021 to the 2022 school year, including, as Gloria mentioned, Amanda Gordon's poem. In Texas, a law was signed by Governor Bill Lee, which makes it a felony for book publishers to distribute or sell any books that have quote unquote obscene material to public schools that serve K through 12 students. Those who are found to violate that prohibition would face between 1 to 6 years in prison or a fine of at least $10,000. In Texas, Texas just passed a bill in the state House of Representatives, which would require book vendors to give books with any reference to sex a rating of either sexually explicit or sexually relevant. Books that are rated as being sexually explicit cannot be sold to schools, and those that are deemed sexually relevant would require parental approval for the students to have access to them. And on the federal level, a Republican has introduced a bill back in February, which would prohibit a publishing house from knowingly furnishing any sexually explicit material to schools or any educational agency. The ban would limit any federal funds to be distributed to schools that obtain any sexually explicit material. There have also been laws enacted in Missouri and Indiana and Louisiana that attempt to ban the access of books in public schools. So as you can see, there's been a lot of activity all across the country to ban books. The focus has been on books geared towards young adults, and the categories of books that have been targeted for, mostly targeted for banning and limiting access to have been books about race, books about gender, books about sexuality, as well as books about religion. Those who are opposed to young people having access to those books deem those books to be inappropriate for minors.
I don't know if Professor Brown Marshall, you want to talk about the impact of these new restrictions, whether it be on the First Amendment restrictions or you know, the legal implications, whether it be short term or long term.
Well, thank you. And thank you, Nakia. I think it's important when we hear these numbers in the hundreds, when we hear the state laws that are being enacted, that we keep in mind, once again, the power to do it, hiding vital information, and controlling social change. Those seem to be the three themes that will flow through this discussion and what people are trying to do. Hide social change, meaning that ever since Barack Obama became the president of the United States as the first Black president, there is this sense that the power of African Americans, the power of people of color, power of women because of Title IX, and of course, because of US Supreme Court decisions, the power of the gay community is something that's seen as a threat to the societal status quo. And so those within society are using their children as, I would say, basically pawns in this game by saying it affects my child in a negative way in K through 12. I want us to think about those particular discrete groups that Nakia has pointed out, because we're not talking about books by white women that are being banned. We're not talking about James Patterson, you know, one of the most successful authors in the country. We're not talking about those books, and those books and they as authors know that they're trying to ignore the fact that the focus of these bans is one against the groups that are rising in power. Political, economic, and social power, rising into the highest leadership as President Barack Obama did in the world of business and education, in the arts and sports. And so that is an undeniable rise that certain people fear. And they are using their legislative power to undermine this. We also have individuals within the communities, the same way we had the Karens of the world crying out that, you know, this person is a threat because they're selling Girl Scout cookies while Black, you know, barbecuing while Black, living, driving, walking while Black. We have people who feel that rise individually being a threat to them in some way, that they can trigger the legislative process by saying my child is harmed by this, by being made to feel uncomfortable. What does that mean, to be made to feel uncomfortable? When we read about Pearl Harbor, and I've been to Pearl Harbor, to the memorial site there, I was very moved by that, the fact that this country was attacked. Do we not discuss Pearl Harbor and World War II in our schools in K through 12? Because people could be made to feel uncomfortable about the losses that took place during Pearl Harbor, or the losses that took place in any American war. What part of American history are we deciding to ban? And we see that it's those discrete groups that other people believe are gaining too much power, or have a sense of self, are becoming first-rate American citizens with in a decision that they want. We want, as an African-American woman, the history to show who was a part of this country's background. That's why Dr. Carter G. Woodson's work was so remarkable in the early 1900s, to not only say that African-Americans had a history that needed to be studied, but it also needed to be written and published, researched, and disseminated. None of the publishers would do it. None of the bookstores would do it. So he started his own publication company. And it was through that these books and the research that took place during that time. Now, remember, he is the second graduate with a doctorate in history from Harvard, and yet he did not have his work published. So in the time period in which we're looking at in American history, the sense that we are going to tell a story about America that's going to have a narrow focus, in which there are going to be certain people who are the heroes, and other people who are either going to be the villains or not talked about in the American history story at all. The narrative was supposed to be so narrow. And as people gained power and began to add their stories to the narrative of what America is, who helped build it, and some of the transgressions that took place in that building, those people with political power are deciding we're not going to allow that story to be told to our children. We're not going to allow that story to be disseminated in our country. And we're not going to allow those publications to be published in the first place, but also when you think about a criminal consequence to publishing houses for actually publishing American history, publishing novels and fiction, through this ban on critical race theory. Critical race theory actually began as critical legal theory. Derek Bell, who was one of my mentors, who wrote the foreword for my book, Race, Law, and American Society, said that we have to look at law from a critical race lens, not just from a legal lens. One thing that I've always said, we can have more Black lawyers or other women or other people of color. We can have people who are gay or queer in these areas, but if the law remains the same, then we're just applying the same biased laws. He wanted us to examine the laws themselves for bias and the effects of those laws on people personally and professionally. Critical race theory is a legal theory, but the phrase is thrown around in ways in which people do not understand. We saw this in the hearing for then Judge and now Justice Ketanji Brown Jackson, where the questions were asked about critical race theory from people who had no idea of how to define it or how to apply it. So critical race theory is now seen as the boogeyman in many ways that allow for the banning of books. I'll leave with this point. I had the opportunity to speak in Florida during Black History Month. And there was a great deal of controversy around whether or not I would be able to speak. I was told there were certain words I couldn't say. I couldn't say diversity. I couldn't say critical race theory. I couldn't say inclusion. I couldn't use the word racism. I was speaking at a college, a public institution, and I was told that I could not use these words. So instead, I used the D word. I use the idea behind, inclusion. I talked about these concepts because that's what they are. We can change one word to another, but the concept remains the same. In 1619, 20 and odd Africans arrived in the Virginia colony, the Jamestown settlement. This colony was founded by the English in 1607. The Mayflower landed in 1620. We were here before the Mayflower, the land of the Powhatan Native Americans. It was in the 1600s that this country had diversity. That story is being told in ebbs and flows through the 1619 project, and that itself is being banned. History is what it is, and people can delay the knowledge of this history by delaying access for this history to reach their children. But it is what it is. This country has done what it has done, and we will continue to research it in the best ways we can. And at some point, hopefully, the young people who are being denied this information will soon seek it out. And they'll seek it out and ask the question, I hope, why were you afraid of your own history?
Yes, the disproportionate impact on certain communities, certain races, public forums of public libraries, public schools is disheartening because we know who it's going to impact, the average person.
Right.
And we
I just wanted to add.
Oh, please.
I'm sorry, I just wanted to add one thing, Gloria. Something you said made me think of the Stop Woke Act in Florida that was signed into law by Governor DeSantis last year. And Stop Woke is an acronym for Stop Wrongs to Our Kids and Employees, which the law specifically sets out to restrict how conversations about race and gender take place in college and in the workplace. and to prevent discussions that make people feel guilty or uncomfortable about past wrongs, right? The law is being challenged in court. A district court judge blocked portions of the law which restrict discussions of race and gender and inequality from being enforced, and the 11th Circuit upheld that. But nonetheless, the idea that a law would be put into place to prevent how people have conversations, to prevent certain groups of people from feeling quote unquote uncomfortable, seems like a great, government overreach.
I remember being in the US Supreme Court press box, watching arguments in the Harvard affirmative action case. And I remember Justice Gorsuch referring to conversations around race and people learning more about diversity and inclusion as indoctrination. And now we have a US Supreme Court justice saying this, using that word, indoctrination, as though to actually learn more about this history is to be indoctrinated into a mindset that that one is no longer of free will and control. I mean, we are learning about all aspects of the world as educated people, and here he is on the US Supreme Court, who is the person who's supposed to be open-minded enough to take each case as it comes. But I would turn the table and say it's indoctrination to believe that the country only has one history, and that's a history that he learned some time ago and wants to continue to hold on to no matter what. As more women gain access to the marketplace, their ideas are also going to gain access to the marketplace. I wonder, because I was an attorney at a time period when women couldn't dress a certain way, you couldn't speak too often, you had to be quiet and be glad that you were in the room. Do we really want to go back to that time period? So even if you're not in one of those groups that's being maligned right now by having their books banned, because just like segregation, what Homer Plessy said, that segregation gave a badge of inferiority to a certain group of people. Book banning gives a badge or a maligning of certain people and their ideas, because why wouldn't a book need to be banned unless that person's ideas were dangerous in a way, or the person who wrote it had something that they were doing that was wrong? And that's the message that's being sent with a book ban. When Amanda Gorman gave her poem, people applauded her as a young person giving a poem in the inauguration celebration of the President of the United States. That poem is now banned. And part of that poem speaks of language of this country coming together. What part is making people uncomfortable? Is it the knowledge that what this country has done to be the great country it is economically, militarily, that it took land, that it enslaved people, that it forced segregation on all people of color? That is the reality of history. Or are we to look back 20 years from now and be ashamed of this time period and want to figure out legislative means to hide it as well? I want to add this: the Scopes trial that dealt with evolution was a sensation. Clarence Darrow, who's the attorney who was representing the people who believed in evolution, was heralded as this brilliant lawyer and mind. We look back now and say, oh, that was such a strange time that somebody actually had a trial that was watched nationally about evolution. We're in that same time period now, where we'll look back at this time and wonder, what were we thinking as a nation to allow book banning, book burning, and children to be left ignorant?
Yeah, I mean, you spoke about the impact of all of this, and the impact is clear. It's to stoke, partisan flames and to contribute to further cultural divides. And the impact is also a chilling effect on book publishers, libraries, teachers, and even students. If you have laws that are in place that penalize publishers from publishing certain content, they are less inclined to publish that content. Authors are being discouraged from creating works that may be deemed inappropriate or controversial in the future, right? Teachers are limited in the kinds of content and the kinds of conversation that they can include in the curriculum. Students, young people are having a harder time having access to books that speak to their experiences and that can help them with whatever challenges they're facing, finding themselves as young people. And so this has broad ranging, chilling effect on large swaths of our population.
And I want to add this academic freedom. As a professor, and for those people who are in the audience who are teaching, whether or not full-time or as adjuncts or lecturers, this is also a part of the issue. There's a lawsuit in Florida that is making its way up around the issue of academic freedom. How teachers, professors, and others are being told what they can and cannot teach. I want us to think about how African-American studies, women's studies, ethnic studies of any kind will then be truncated because people are afraid to teach the subject area of their expertise. How many people will no longer go into those fields of academia, no longer get master's degrees or PhDs in African-American studies, women's studies, ethnic studies of any kind, because they believe there will be no jobs in those areas because those colleges, public colleges and private ones probably as well, are limiting those departments. Some of those departments are being taken off altogether, taking those departments out, not funding them. Then we have the advanced placement test. And in Florida, the advanced placement test was a test that had started an area in African-American studies. And I remember taking advanced placement classes in high school and then taking the advanced placement test when you graduate. An advanced placement test, for many of you know that that's the test that says if you pass certain tests based on classes taken in high school, you don't have to take those classes in college. And so there was an African-American advanced placement class curriculum that was pretty much gutted because there's this idea that what is African-American history to be studied in the first place? And why should our young people be allowed to have classes that would give them credit in college for African-American history or African-American literature? I want people to understand this is quite important. They come for these groups today. They're coming for you tomorrow. Too often in this country, we sit back and as Lonnie Guinier, the brilliant attorney who's now passed away and law professor said, African Americans are the canary in the cage. We're the canary in the coal mine. When the coal mine is filled with gas, the canary passes out. His little lungs can't take it. African Americans too often, unfortunately, have been those people that first happens to us, then it happens to the other groups. Why sit back and wait like this is some reality show, then wait for it to happen to you? We need to come together, and unity is one of the mechanisms that we can use to fight these bans. We need to stick together to fight these bans and understand that that book that you have on the side of your bed that you've been reading half of it and then dropping off to sleep, that book may be banned next week. We don't know when this will be in our living room, our libraries, our local schools. And we need to understand that although it's in Florida right now, as Nakia has pointed out, it's moving across the country very quickly.
Yeah, and speaking about unification and efforts to resist book banning, luckily there are lots of efforts to resist these efforts. There are grassroots efforts. I've read about Black students in Texas and in other states that have joined with parent groups to form organizations to resist book banning. One such organization is called Book Ban Busters. And they do education and offer resources and support against book banning. The writers group PEN America has also filed a lawsuit. They've joined up with Penguin Random House, and they've sued Florida school districts over its removal of books about race and LGBTQ+ identities. The lawsuit says that the removals stem from objections from one teacher in the county, and that in each case, the school board voted to remove the books over recommendations from a district review committee that deemed the books educationally suitable. Illinois is the first state in the country to pass a bill aimed at preventing book banning. The bill authorizes the Secretary of the State's office to restrict funding from libraries that don't adhere to the American Library Association's Bill of Rights, which says that reading materials should not be removed or restricted because of partisan or personal views. The Biden administration also announced recently that it will appoint a new coordinator at the Education Department to address an increase in book banning. That point person will make schools aware that book bans can violate federal civil rights law and that they can create a hostile work environment for students. Also in Texas, a new legal argument has emerged. Most book ban challenges are on First Amendment grounds, but the ACLU of Texas has filed a complaint with the U.S. Education Department's Office for Civil Rights, claiming that Texas school districts book banning policies violate Title IX's prohibition against discrimination on the basis of sex, because it removed 130 books from library shelves, and at least a third of the books featured LGBTQ+ themes and characters. So luckily there are efforts to push back against this. People are not going away quietly.
And I want us to talk about the legal standard for a moment. The case from 1982, Board of Education Island Trees Union Free School versus PICO, P-I-C-O. The case goes to the United States Supreme Court on a First Amendment issue of whether or not this school could have these books banned. The Supreme Court said that the school district does not have an unfettered power to ban books, that it was a First Amendment violation. So I want us to understand that when it comes to, as Nakia pointed out, a committee that decides on a school board that a certain book is inappropriate, their ban does not have to be the final word. That there can be an action taken under this case, this 1982 case, and the U.S. Supreme Court has not clearly found the voice to speak on the issue of book banning yet, but I think the cases are on their way up. But it should be understood that the school board does not have unfettered power to ban a book. So even after a decision is made on that local level, that decision can be challenged. I didn't know if we had questions from the audience.
Yeah, I was going to say we can move to questions. We have at least a couple of questions which I can bring to you now. The first was about the Texas law. It says the law in Texas that requires parental approval. Would you please clarify this? Is it for K through 12? Because parental approval, it seems, I guess, broad reaching for certain ages.
Yes, it's House Bill 900 in Texas. And actually, I just read that Governor Abbott has signed that bill as well as others into law. He characterized it as a parental empowerment legislation. So yes, it is for K through 12. The bill essentially prohibits the possession, acquisition, and purchase of library materials that are sexually explicit. But it does allow for parents to consent to their children having access to some books that have sexual content, so long as they are deemed to be sexually relevant.
But I want us to think about that. I think within that question, we're looking at a third grader and someone who's a high school junior or senior, and saying that the parent has to decide whether or not this child can read a particular book. And the sense that politically astute conservatives have said, well, if we play to the power of the parent, remember, this is all about power. If we play to the power of the parent, then we can say we're signing this bill in order to empower parents. But we know that parents are not deciding the reading materials of a 17-year-old. So much of this is being played out in the political sphere with ramifications where in my travels internationally, and I've just come back from Europe and Africa, this country is looked upon as off the path. I asked the question to many people in my travels, what do you think of America? And they said it's going to a place of no return, that at some point, if it doesn't see that it's on the wrong path, then it's going to lose its power in the global political sphere. And when you're talking about book bannings, when you have someone who is running for office and has so many indictments, I think from the outside, the global perspective of this is that this country is supposed to be a shining light on the hill of democracy. That's what it said it was, and that's what the goal was supposed to be. I really believe that not just symbolically, but literally, and I'm saying literally in a way that's very literal, that this country is not only on the wrong path by banning knowledge, it's also sending a signal to the world that it may not be the country that should be the leader it wants to be.
And I would echo that, especially in this time when young people are really stepping up. And we saw with some of the civil justice movement and environmental issues, sexual orientation issues, young people, it's the children that are raising their voices and saying, wait a minute, this is the direction that we think we should be heading. These are the issues we need to talk about and deal with. And to stop that under the guise of parental approval or guidance, it's quite interesting. I'm going to speak in one more.
It's almost as though that the young people are saying, don't do this in my name. Because these laws are based on the parents trying to protect the children, and the young people are saying, no, you're using me as a political football. Don't do this in my name.
Yeah, exactly. I'll sneak in one more question. It says, please comment on the use of revisionist language in classic works of art in an attempt to make them more palatable.
I'm thinking, and I'm a writer and a playwright as well as a social justice activist and an academic. And so I know that certain people have looked at works of art and other works of literature and said that those works were written by people who were slaveholders or thought of women in a certain way or acted in ways that were quite inappropriate. What happens with censorship is that once we begin to censor one part based on the aesthetic of certain people, then we could end up in the reverse book banning, where we're deciding that we want to, as an adult, not even have this book on the shelf. I think that you could have the book on the shelf, but it doesn't mean I need to buy it. Or I finally read Lolita. I was, really apprehensive about ever reading this book, Nabokov's book, but I read it in a class. I lived through it. I'm still here. I can see why it can be considered a great work of literature, but it's not my top book, but that's a choice for us to make. That's the great thing about living in a democracy. You choose what you want to read as an adult, and what you don't want to read, you leave on the shelf.
Yeah, and just to add to that, this racist backlash against diversity and representation is happening in other forms of media as well. I mean, we recently, the whole controversy around The Little Mermaid, and Halle Bailey, a Black actress, being named as the lead character of Ariel, and the level of backlash that received over the course of the last two or so years. There was a point where the hashtag #NotMyAriel was trending on social media because people were so outraged that a Black woman would be playing this character that it's traditionally white, a white woman with blue eyes and red hair. So clearly there is a resistance to diversity happening all across the country in various media outlets. There's a resistance to Black people, young Black people rising up and being placed in prominent positions. This whole backlash with The Little Mermaid was even more ridiculous because the idea was that having a Black actress was not authentic to the story of a mermaid. I mean, it's fictional, it's fantasy, it's a mermaid, which is half human, half fish, who lives under the sea and has a crab as a best friend, a talking crab. None of it is realistic, it's all fictional. So what does it matter if the lead actress is Black? So yeah, it just goes to show that we have a lot of work to do as a country.
I just want to, and I know we're down to the last moments, I want us to really ask ourselves what kind of community we want, what kind of country we want, and is this what we want to represent our generations? I want us to understand that this is the history that we're leaving. And as we leave our mark, we have to ask ourselves, is this what we want to have representing our time on the planet? Is this the legacy that we want to live and leave and have representing our time here? And I think we can do better than this. And it means more than just sitting back and letting other people do the work. We are lawyers, we are advocates, we are people who have a special gift. And that gift, even though you may not feel it right now, is something that the average person does not have. We need to use our training, we need to use our access, and we need to get to work to make the country, our communities, our hometowns into what we believe is the best of us. And that means that it might be difficult, but the fact that we have people of color, women, people of all sexual orientations, we have all of these people now in the profession. So that means that we have to get to work to continue to make our communities as diverse as what we believe this country should be, and not sit back and let people use their power to undermine social change and to keep information from being gained by generations to come.
Well, I can think of no better way to close this off. Thank you both. Thank you, Nakia Martin and Professor Gloria Brown-Marshall, for your wise words, for your challenging words, and for such a provocative conversation and discussion today. I also want to thank all those in attendance, as well as the Committee on Diversity, Equity and Inclusion, Committee on Civil Rights, the Task Force on Racism, Social Equity and the Law, and the Committee on Continuing Legal Education of the New York State Bar Association. On behalf of the Women in Law section, thank you all and have a wonderful afternoon. And I don't know if you say happy or, I don't know, a positive Juneteenth.
And I would just like
Thank
to echo Fredra's sentiments there and thank Professor Brown-Marshall and Nakia for joining us for that wonderful, thought-provoking, and impactful program. This does conclude the webinar, so please make sure to return to your My Learning dashboard and complete the course evaluation. Thank you for choosing New York State Bar Association programs, and enjoy the rest of your day.